Apple may be the big event of the day, but we can't forget about the record settlement against JPMorgan that should be finalized in the next few days. Charlie Gasparino is here now for an interview with Tom Gorman, securities lawyer at law firm Dorsey Whitney, to discuss what threats JPMorgan still faces. Charlie?
Tom, how are you? Great. Thanks for joining us. Let me ask you this.
Thank you for having me.
This is a kind of, I think, where everybody's focused on the $13 billion, this current deal, which be nice to get it done. From what we understand, this week could be the week it's finished. But there's the future, the private litigation that could come out of this. And a lot of that revolves around the concessions that JPMorgan are going to have to agree with, the facts that in this settlement. Just how important is this? I mean, where do you see this thing going?
Well, there's two open questions here. One's the criminal cases that we can come back to if you'd like. The other is what you brought up, and that is the so-called admissions that the government will extract from JPMorgan. They're negotiating those now, and what they say in them and how they say it and what they go to can be all important to potential liability down the road in the future in class actions for JPMorgan. You know,
listen, the stock, our audience are shareholders, and they always want to know how to play a stock. If you were a shareholder, this has got to be the biggest thing on your plate if you're a JPMorgan shareholder, because this thing could cost, I mean, is it possible that we're talking another $10 billion here, depending on what they agree to in this?
It's possible that there could be a lot of exposure in the class actions, but I don't look for these admissions to have that kind of character. I think you're going to see admissions that are more driven by straight facts, something like what the bank did with the CFTC, and they won't have the kind of intent elements that the class action people need to prove their case. Because remember, the statutes that the government chose to bring these cases under are the S&L era statutes. They ease the proof burdens for the government, but that doesn't necessarily mean it eases the proof burdens for the class action folks. So these will be helpful, but not necessarily definitive.
Well, you know, even before we had an administration that's kind of in bed with the trial lawyers. We do know the Obama administration is very close with the trial bar. There's a movement afoot in the Obama administration to get banks and people that they cut these deals with to admit something. Even in another era, you know, class action lawyers did pretty well. Isn't the class action aspect of this kind of a bigger risk now than it was ever before?
It's clear that the class action bar is watching these things. They want to see what's going on, and these will help them. There's no doubt. Just a straight set of facts admitted by the bank is going to help the class action people. But the key to most of these class actions is they're brought under the securities laws. They need to prove intent. That's not the same standard that the bank's being held to here by the government.
I got you. I got you. So it helps, but it's not the bullet that can really damage the bank, is essentially what you're saying.
That's right.
Okay, so let me ask you this though. You've seen a lot of these cases. I've seen a lot of them over the years where, you know, firms pay up a lot of money. There's usually a structural change at the bank because of this. I mean, is Jamie Dimon, is he going to lose his job or part of his job? I mean, there's never before been a time where I've seen a CEO, you know, pay $13 billion or something on this magnitude and escape unscathed.
That's true, but you got to take a look at what Jamie Dimon's doing here. Remember, he's the one who instituted this settlement, and it's clear what his goal is. He wants to move past this and get the bank into the business of running the bank and not running their litigation. So he's moving hard to get there. He's also spending $6 billion more.
I know, but how does he escape how does he escape not giving up his chairmanship on this thing?
I think it's a very difficult question for shareholders to look at what's going on here, and you look at the string of settlements they have in a whole series of cases, and not say there's something wrong with the way the culture is playing out here. So I think shareholders have a tough choice.
So you think it's more than a theoretical possibility that he gives up his chairmanship based on what you've seen in the past, correct?
I think there's a real possibility that there's going to be real issues here that he's going to have to deal with and see if he can survive.
All right, Tom, I'd like to leave it there. Tom Gorman, thank you.
Thank you.
Okay.